Question 576. Ms. Adams made a deposit on the purchase of a property. During the escrow, the seller learned of a highway rerouting which would greatly enhance the value of her property. She instructed the broker to return the deposit to the buyer. Ms. Adams refused to accept the deposit. Her most unlikely course of action would now be A. To pursue a lawsuit for specific performance from the seller, B. Unilateral rescission, C. To file a claim for monetary damages, D. To accept a settlement. Correct answer is B. Unilateral rescission. Ms. Adams has a valid contract and the seller is breaching it. Specific performance is a legal remedy where the court orders the seller to proceed with the sale as agreed. This is a very likely action for a buyer who wants the property, especially when its value has increased. Even if Ms. Adams doesn't want to force the sale, she has likely incurred costs, inspections, appraisals, time, due to the contract. She could sue the seller for monetary damages to compensate her for these losses resulting from the seller's breach. Litigation can be costly and time-consuming. It's quite possible that Ms. Adams and the seller could negotiate a settlement, perhaps involving the seller paying Ms. Adams some amount of money to release her from the contract. The most unlikely course of action for Ms. Adams would be unilateral rescission. Unilateral rescission means one party decides to terminate the contract without the agreement of the other party and without legal grounds, like fraud or misrepresentation. In this scenario, Ms. Adams has a valid purchase agreement and the seller is attempting to back out due to a change in circumstances that benefits the seller. Ms. Adams has no legal basis to unilaterally rescind the contract. In fact, she wants to proceed with it. To rescind unilaterally, give in, with nothing in return from the seller, would not gain her anything. Question 577. Which of these real estate transactions are exempt from the disclosure requirements in the California Civil Code that apply to conveyances of 1-4-unit dwellings? A new home sold in a subdivision where a public report is not required. B. Foreclosure sales. C. Transfers from one spouse to the other. D. All of the above. Correct answer is D. All of the above. Based on California Civil Code, the following real estate transactions are exempt from the standard disclosure requirements that apply to conveyances of 1-4-unit dwellings, primarily the Transfer Disclosure Statement (TDS). 1. Transfers pursuant to court order. This includes probate sales, sales by a bankruptcy trustee, etc. 2. Foreclosure sales. This includes a deed in lieu of foreclosure and a transfer by a beneficiary who has acquired the property by foreclosure or deed in lieu of foreclosure. 3. Transfers from one co-owner to one or more other co-owners. 4. Transfers made to a spouse, or to a child, grandchild, parent, grandparent, or other direct ancestor or descendant. 5. Transfers between spouses in connection with a dissolution of marriage or similar proceeding. 6. Transfers by the state controller pursuant to the unclaimed property law. 7. Transfers as a result of failure to pay property taxes. 8. Transfers or exchanges to or from any government entity. 9. New homes sold in a subdivision where a public report is required under Business and Professions Code Section 11018.1. These have their own disclosure requirements. However, new homes in smaller subdivisions where a public report is not required might still be exempt from the TDS. 10. Transfers of a leasehold interest exceeding 1 year, though disclosures might still be practically advisable. It's important to note that even in exempt transactions, sellers, if they have knowledge, still have a common law duty to disclose known material defects that could affect the property's value or desirability. The exemptions primarily relate to the specific statutory requirements of the Transfer Disclosure Statement. Question 578. During escrow, if the escrow instructions are in conflict with the deposit receipt, then the A. Escrow instructions are to be followed. B. Deposit receipt is to be followed. C. Seller can withdraw his offer. D. A new agreement between the parties must be executed. Correct answer is A. Escrow instructions are to be followed. Escrow instructions are the specific, binding directions given by the buyer and seller to the escrow agent outlining the procedures and conditions for closing the transaction. They are typically drafted after the deposit receipt, purchase agreement, and are intended to provide the detailed steps for carrying out the terms agreed upon in the deposit receipt. The deposit receipt, purchase agreement, is the initial contract between the buyer and seller that outlines the fundamental terms of the sale, such as the price, financing, and closing date. If a conflict arises between the deposit receipt and the later escrow instructions, the escrow instructions, being the more recent and specific directions to the escrow agent, generally take precedence. This is because they represent the parties' updated and more detailed agreement on how the transaction should proceed through escrow. The seller cannot unilaterally withdraw their offer simply because there's a conflict between the two documents. The existence of a conflict usually necessitates a resolution based on the later agreement, escrow instructions. However, if the conflict is significant and prevents clear execution of the transaction, the escrow agent might require further clarification or a new agreement between the parties. Question 579. Principals face personal liability to creditors in A. Limited partnership. B. Partnership. C. Corporation. D. None of the above. Correct answer is B. Partnership. In a limited partnership, LP, general partners usually bear personal liability for the partnership's debts. Limited partners, however, typically have their liability capped at their investment amount, as long as they don't actively manage the business. This structure offers some partners liability protection while others retain management responsibilities and associated risks. A corporation is a separate legal entity from its owners, shareholders. This separation generally shields the shareholders from the corporation's debts and liabilities. The corporation itself is liable for its obligations. This is the concept of limited liability. Partnership. In a general partnership, each partner is personally liable for all the debts and obligations of the partnership. This means that if the partnership cannot pay its creditors, the personal assets of the partners, like their homes, cars, and savings, can be at risk. This is known as joint and several liability. Question 580. The land description method that refers to the terms townships, sections, and ranges is A. Leaps and bounds method. B. Government survey method. C. Rectangular circumscribing method. D. Land analysis system. Correct answer is B. Government survey method. Also known as the rectangular survey system or the public land survey system, PLSS. This method was established in the United States to survey and divide land. It uses a grid system based on principal meridians, north-south lines, and baselines, east-west lines. Townships are 6-mile by 6-mile squares, and each township is further divided into 36 1-square-mile sections. Ranges indicate the distance east or west of a principal meridian, while townships indicate the distance north or south of a baseline. Question 581. Which of the following is considered an advantage of FHA loans over conventional loans? A. FHA loans usually have a higher loan-to-value, LTV, ratio than conventional loans. B. FHA loans do not have to be paid back until at least 4 years after the loan is made. C. FHA loans are more likely to have lower interest rates than conventional loans. D. Both A and C. Correct answer is D. Both A and C. Due to FHA loans' higher LTV, an FHA loan typically requires less cash put down at closing than with conventional loans. The FHA insurance reduces the lender's risk. which can translate to more favorable interest rates for the borrower compared to uninsured conventional loans, especially for those with less than perfect credit or smaller down payments. FHA loans have standard repayment terms, typically ranging from 15 to 30 years, with payments starting shortly after the loan is originated. Question 582. A long-time general rule of contracts states that a party's acceptance of an offer is effective upon dispatch, even before the acceptance is actually received by the other party. This is called the A. Effective dispatch rule, B. Acceptance timing, C. Mailbox rule, D. None of the above. Correct answer is C. Mailbox rule. Acceptance timing is a general term and doesn't specifically refer to the rule regarding the effectiveness of acceptance upon dispatch. Effective dispatch rule phrase accurately describes the concept, but mailbox rule is the more widely recognized term. The mailbox rule is a legal principle that states that an acceptance of an offer is effective upon proper dispatch even if it's delayed or never received by the offerer. The mailbox rule has been expanded to cover all technology by which commercial communication may reasonably be conducted, including telephone, email and fax. Question 583. A property's selling price appears on a buyer's closing statement as A. Debit to the buyer, B. Credit to the seller, C. Debit to the seller, D. Credit for the buyer. Correct answer is A. Debit to the buyer. The selling price represents money the buyer owes for the property. Therefore, it's recorded as a debit, which increases the amount the buyer needs to bring to closing. The selling price also represents money the seller will receive for the property. Therefore, it's recorded as a credit, which increases the amount the seller will net from the sale. So, the selling price appears as both a debit to the buyer and a credit to the seller on their respective closing statements. Question 584. The following state differences between a trust deed and a mortgage, except A. The party that holds the security, B. The way title is conveyed, C. The number of parties, D. Both B and C. Correct answer is A. The party that holds the security. In both a trust deed and a mortgage alike, the security is held by the lender. As for differences, a trust deed has bare legal title conveyed to the trustee, while a mortgage has title maintained by the borrower. Also, a trust deed has 3 parties, a mortgage has 2. Question 585. The document used in a business sale that is akin to a grant deed in the sale of a home is called A. Bill of sale, B. Deposit receipt, C. Business transfer statement, D. Bulk sales security agreement. Correct answer is A. Bill of sale. Deposit receipt is a preliminary agreement in a real estate transaction, outlining the terms of the offer and acceptance, along with the initial deposit. It's not the final conveyance document. In a business sale, there might be a similar preliminary agreement, but it wouldn't be called a deposit receipt in the same way. Business transfer statement isn't a standard term for the transfer of business ownership in the same way a bill of sale is for asset transfer or a grant deed is for real property. There might be documents with similar titles used in specific contexts, but bill of sale is the more common and direct equivalent. A bulk sales security agreement is related to the Uniform Commercial Code, UCC, and is used to secure a loan against the assets being sold in bulk. It doesn't primarily function to transfer ownership in the same way a bill of sale does. Grant deed, real property, is the primary legal instrument used to transfer ownership of real property, land and anything permanently attached to it, from the grantor, seller, to the grantee, buyer. It implies certain warranties from the grantor to the grantee. Bill of sale, personal property, business assets, is a legal document that transfers ownership of personal property from the seller to the buyer. In the context of a business sale, the majority of what's being transferred, inventory, equipment, furniture, fixtures, intellectual property, etc., is considered personal property, not real property, unless the sale includes the land and buildings. The bill of sale serves as the formal written evidence of this transfer of ownership of the business's assets, similar to how a grant deed transfers real property.